Hello everyone, welcome to Anu's classroom, and in this video we are talking about Partnership Act. Okay, so this is from block 2 of MMPC 13, that is unit 3 of MMPC 13. Now, as you might see over here, right, I have written important. That is because at least one question has come up from this particular unit alone in all the previous year question papers that I have asked. So this is a very important unit. I would suggest that you do not skip this unit. And go for your term and examinations. Okay, this unit, if you check in MMPC 13's textbook, the study material provided by IGNO, you will find that this is one of the biggest individual unit as well in the course. Okay, so but I would highly recommend that if not any other block, thoroughly study block 2 and go. Block 1, you will get one question from which it will start with define the business law, and they might ask you for the scope or significance or nature, things like that. And from block 2, Partnership Act, definitely there will be a question. That has been the pattern so far, so I am expecting the same pattern to continue. So I hope that you would have understood by now how important this video is going to be. I will try to keep it to the as short as possible by telling you about the important concepts that there is, but please bear with me if it becomes a little bit lengthy, okay, because I don't want to skip anything being such an important unit. So before we get into the core concepts of Partnership Act, we should understand what exactly partnership means. This is a common term. You might have all heard of this term, right? Partnership. So what is partnership? So partnership businesses, they are those forms of businesses where people, okay, individuals come together, and what they'll do is they'll say, okay, I have this much amount of money with me, the other person has so and so money with me. I have a maybe one of them would have maybe a what you can say, a shop space, which is what you can say, which is there empty. So maybe they'll say, okay, we can use that shop space to run our business, things like that. So they pool their economic as well as like financial as well as non-financial resources together, and they form an agreement within themselves and conduct a business. Such businesses are called partnership. Now, one important thing that we should understand over here is there is another term called co-ownership. Okay, and the partnership and this co-ownership, those two things, they might seem to be like kind of like similar to each other. Okay, maybe you might get a tendency to interchange them, like if in case question comes about co-ownership. Okay, you must understand that there is a very fine line that demarcates a co-ownership from a partnership. So as we said, right, in partnership also, in case there is a property with one of the partners, and they decide to use it for the bringing or the conduct of the business, that is partnership. But suppose say one property is owned by two people or two or more people. Okay, the property is was bought or is established under the name of more than one people, and that is being used for the business, means it becomes co-ownership. Like for example, in nearby my house, okay, I belong to the Irava community, so it is SNDP. So what happened under the people our community, a few of our community members, they got together and they bought a piece of land, and now they are building a shopping complex on it. So what happened is that, so that will be registered, so that property was said to be registered under all their names because they all have contributed to it. So that is not partnership, that is co-ownership. Okay, but you might see that two or more friends, they form a partnership and they start a business. Okay, so that's fine demarcation line between co-ownership and partnership. I hope you understood that. Now, what exactly is partnership? So there is an act called Partnership Act, which is established as early as like 1932, even before the Britishers left. Okay, so this Partnership Act was established in India, and as per section 4 of that Partnership Act, partnership is defined as the relationship between people or persons who have agreed to share the profits of the business carried on by all or any of them acting for all. So acting for all, that means if I'm a partner in a business and I do something, then it is automatically what you can say, assumed that I am acting for the rest, on behalf of the rest of the partners as well. Okay, so that is the thing. if I say something, then it automatically comes to the outside world or the outside of the firm. They treat it as all the partners have agreed, whether or not they have agreed. So that is one clause, acting for all, which is very, very, very important. Okay, so what are partners then? The partners are people who have entered into the partnership with one another. Firm is a collection of these partners, and firm's name is the name under which the business is carried out by partners. So these partners who have entered into a partnership. So partnership is something that is established by the act of creating an agreement. Okay, the agreement might be written or mutual through mutual consent, whatever it is. There is an agreement between the partners, and that is how the partnership has come into force. Now, partners have both duties and responsibilities. Okay, so what are the duties of a partner or partners? Few of the duties are as envisaged in the partnership contract. I said, right, partnership is through an agreement, mutual agreement between the partners. So in that agreement, they might have said that certain partners will be responsible for certain things and all. Or so those duties will definitely be there. And on top of that, there are duties which are bestowed upon these partners automatically according to this Partnership Act of 1932. Those duties are duties of good faith, duty to indemnify for loss caused by fraud, duty of due diligence, duty to proper use of property, duty to account for profit and pay it to the firm, duty not to compete. These are a few of the duties. Similarly, rights of each partner of the firm has certain rights. In the normal course of a partnership, they have right to participate in the conduct of a business. If, say, suppose I am a partner in a business, okay, and all the other partners are doing the business without me, I can protest because it is my right to participate in the conduct of that business. It is not that it's just that I gave you money, now you just ignored me. No, that is not going to happen. You have the right to participate in the conduct of the business. You have the right to be consulted, right to access to the books of the business or the firm, right to share the profits, right to be indemnified, right to use the partnership property. Okay, then under special circumstances, okay, this is the normal rights that definitely you will have. And under special circumstances, like maybe there is a death of a partner, or maybe you found that one of your partners are committing fraud, or something like that. Those are special circumstances which do not come up that often in the partnership. So under those special circumstances, you have right in emergency, you have the right to retire from a partnership, you have the right to continue as partner, you have the right to prevent the admission of a new partner, you have the right to share subsequent profits after you enter into a existing partnership as well. So these are the few rights of partners. I hope you are clear with it. Then another important term over here when we talk about partnership is the reconstitution of the firm. Okay, reconstitute, okay, means what? It's kind of like when we talked about restructuring of the firm in block 1, what did we say? Restructuring means we are completely changing the structure of the firm, financial structure, or what you can say, accounting structure, whatever that is, that structure we were changing. Okay, so over here we are reconstituting. So what is the firm? Firm is a collection of partners. When can you say that firm is reconstituted? When the the combination of partners that is there, that constitutes the firm, okay, that makes up the firm, changes. Correct? So that is reconstitution of a firm. It takes place whenever there is a change in the composition of partnership. Now this change in composition of partnership could be due to new admission, okay, that is a new partner entering into the firm, death of a partner, retirement, expulsion, expiry of original partnership, etc. Okay, so those are reconstitution of a firm. Then another aspect is dissolution of a firm. Okay, that is the firm is being dissolved. The firm will no longer be there. That means all partners are being dissolved. All partnership is coming to an end. Everybody is terminated. Correct? So there is no more group. The group has become dissolved. Okay, പിരിച്ചുവിട്ടു we say in Malayalam. So dissolution of firm is the termination of partnership between all partners of a firm. This you should understand is different from dissolution of partnership. So when we say dissolution of partnership, we mean that few of the partners are no longer part of this partnership. That is dissolution of partners. Okay, termination of partnership between a few partners. Now, dissolution of firm means all partners are no longer partners. Okay, everybody is gone. There is no longer a firm. If I and my friend were partners in a firm and we are no longer in that partnership, say maybe we had a couple of 3 or 4 friends, we join together and form a partnership. If we decide to kick one out, that is dissolution of partnership, or one of them decide to retire, something like that is dissolution of partnership. Okay, but if we all collectively decide, okay, we are going to stop this thing up for good, then it becomes dissolution of firm, because we are none of us are in a partnership anymore. Okay, so what you must understand is dissolution of a firm always means dissolution of a partnership, but not vice versa. So when does this dissolution take place? Dissolution of a partnership takes place on the expiry of the fixed term for which partnership was formed, on completion of the adventure over here is whatever what you can say, whatever business aim or whatever goal for which you had undertaken this partnership. Like for example, you might have all got together to put up a trip to Pattaya. Once the Pattaya trip is over, you have dissolved your partnership. So that is on the completion of the adventure. Or maybe you guys formed a partnership so that you can create or amass funds for, say, maybe a charity drive. Once that drive is over, you consider it as end of adventure and the partnership is dissolved, things like that. Okay, that is completion of the adventure. On death of a partner, on insolvency of a partner, or on the retirement of a partner. So these are the ways where, or these are the times when dissolution of partnership occurs. Dissolution of firm occurs by mutual agreement between all partners, or by insolvency of all partners but one. Okay, so this is a small typo mistake, not by one, it is but one. By business becoming illegal, or by notice of dissolution. Now, there are majorly, you can classify the modes of dissolution as two. Voluntary, that is without the involvement of any court or any kind of what you can say, any court or legal formalities, that is voluntary dissolution. Or dissolution could occur because of an order from the court. So voluntary definitely is through mutual agreement, by compulsory dissolution, on the happening of some event, or by notice. By order of the court may decide, or the court may issue order to dissolve the firm if on any just or equitable grounds, or if they find out that the partner is insane. They might feel that it is not right for the firm to continue like this. Then the court might order dissolution. Misconduct, continuous loss, permanent incapacity, or if there is a persistent breach of agreement, all those cases the court may order for dissolution of a firm. Then till now whatever I have mentioned have all come for the previous question answers. Okay, question papers, all these concepts have been tested upon. Now the last important part of this unit is this Limited Liability Partnership Act. So far I haven't found any questions from this topic, but this is a very important topic, and it might so happen that this is the topic from which this term and examination might get asked, right? So I hope that you will stick with me for a few more minutes while I explain to you what this Limited Liability Partnership Act is. So far we have been talking about the original Partnership Act. Then it was in 2018 this bill for Limited Liability Partnership bill ascended into the what you can say, into the House on 12th December. Okay, that is when this bill was presented. And by around January of 2009, this bill got passed by both the houses, and it got into practice, or it was formed as an act by January of 2009. But still we call it as LLP Act of 2008 only, because the bill was first presented in 2008 in the December session. Okay, so the LLP Act 2008, it was introduced in India by way of the LLP bill on 12th of December 2008. It extends to the whole of India. It is applicable everywhere in India, and it fundamentally changes the nature of partnership. Okay, so earlier in Partnership Act, according to Partnership Act, this partnership was a very free and voluntary entity. Right. So even a partnership, it was not mandatory that you should register a partnership. The only thing is that in case you have not registered your partnership anywhere, the problem is others might be able to sue you, but you wouldn't be able to sue anybody else because you're not registered. We don't know, do you even exist? That kind of attitude it had. So it was a totally free and a voluntary thing, partnership, according to Partnership Act. But through LLP partnerships, LLP partnership or limited liability partnerships, they are more legal partnership. Okay, so does LLP Act overthrow your Partnership Act? Is that what it means? No, that is not the case. Partnership Act also will remain. LLP will also remain. Okay, so if you want to get into a partnership, you can, but you can also, if needed, can get into an LLP partnership. Okay, sorry, not LLP partnership, LL partnership, limited liability partnership. So it does not harm the existence of the Partnership Act, and they both are independent of each other. And the task of administering this LLP Act is entrusted with the Ministry of Corporate Affairs and the Registrar of Companies. Okay, that is ROC. Pardon for the spelling mistakes. This PPT was actually prepared in a hurry. I'm really sorry. Okay, so it has 81 sessions and 5 schedules. Now, the features of this LLP Act, okay, are that LLP is a body corporate. It acts as a separate legal entity, and the partners of an LLP are what you can say are entitled to perpetual succession. There is very limited liability to the partners, and to form an LLP, at least 2 partners are required. You can have any number of maximum number of partners. There is no cap on the maximum limit, but at least 2 partners have to be there. And an LLP, once you get into an LLP, this LLP is deemed as an artificial legal person, and there is unlimited third party liability to all these partners. Business will be conducted. LLPs conduct business only for profit, and even a foreign LLP or another LLP, another body corporate can become partner in an LLP. So it is not like it should only be individuals, okay? But there is a concept of designated partners who should be individuals, and there should be at least 2 designated partners also, because all the legal compliance mandatoriness always rests with this designated partners alone. Okay, so that is the case here. So those are the features of LLP. Okay, so now we saw, right, earlier we saw LLP, earlier we saw partnership. So how is LLP different from a partnership? So a few of the points where there is a difference between LLP and partnership is filing of documents to the registrar of companies. Okay, partnership need not file any annual what you can say documents. Sorry, it should be to the registrar of firms actually, because partner. Okay, so filing of documents is not mandatory, but LLPs have to. Okay, LLPs have to be registered. Partnership need not be, but to get the full legal protection, you need to register. So it is always good to register. Then the method of creation. Okay, so LLP gets created when you comply and register according to the LLP Act. Whereas for partnership, you get into a mutual agreement between partners. That is how the partnership gets created. LLPs are regulated through LLP Act. Partnership is regulated by the Partnership Act. There is no particular naming guideline or anything for a firm's name for a partnership. But if it is an LLP, it is mandatory that LLP should be added as suffix to the firm's name. Then LLPs can have foreign nationals added, but there should be at least, as I said, right, there should be at least one designated Indian resident in an LLP. Then admission of minors. LLPs cannot admit minors as partners, okay, but minors can be admitted with benefits of partnership with the consent of existing partners. Liability to partners is very limited. That is why it is called limited liability partnership. But in case of partnership, unlimited liability is there for each partner. Okay, each partner if a partnership is an agent of the firm as well as of all the other partners. So anybody can take action on behalf of anyone. But LLP, each partner can take any action on behalf of the firm. That's it. But not on behalf of other partners. So that is the thing. Okay, so that is again another difference. So those are a few of the differences between an LLP and a partnership. Similarly, there is a difference between LLP and company. Again, name of the firm. If it is LLP, means it has to have LLP as suffix along with the firm's name. If it is private, then it should have, if it is a private company, then it should have private limited. If it is a public limited, then it should have limited with the company name. So such company name guidelines are there. How internal governance is done. in an LLP versus in a company. So internal governance structure of LLP is governed by contract between partners, whereas for companies it is regulated by statutes. Okay, LLPs require minimum 2 partners, but there is no maximum cap. But if it is a private company, there can only be a maximum of 200 people, minimum to maximum of 200. Otherwise, if you have to go for a public company where at least 2 people should be there, and there is no cap on the maximum limit. Okay, LLPs are managed by partners, whereas a company gets managed by the board of directors. There should be at least 2 designated partners for an LLP. But if it is a private company, there should be at least 2 directors. If it is a public company, at least 3 directors should be there. Liability for partners is limited to the agreed contribution, except in the case of a fraud, whereas in a company, liability is limited to the amount of unpaid shares held by them. Okay, so those are the few what you can say differences between LLP and company. Similarly, this designated partners, that concept itself is not there in partnership. So that is again another difference that you can write for LLP versus partnership. So in case questions come from LLP, okay, and ask, then you can write all these things. If it is a generic question, then you can write what you understand by an LLP, how is it different from partnership, how is it different from a company. All these things you can write and write for getting marks. Now, what are the few advantages and disadvantages of going for an LLP? Now that we know what the difference is between a partnership or a company and an LLP, what are the advantages and disadvantages? Okay, so advantages are, it is very easy to form an LLP. There is very low cost of formation. It gets treated as a separate legal entity. There is a perpetual existence to LLPs. There is limited liability. There is no minimum capital contribution required to form an LLP. There is no restriction on the maximum number of partners, and it is very easy to dissolve or wind up. Whereas the disadvantages include, it cannot raise any kind of a fund from public sources. If it needs to raise fund, either it has to take a debt, that is loan, from any financial institution, or it has to find what you can say finance from within its partners itself. Okay, there is no separation of management from the owner. Any act of a partner without the knowledge of others can bind the firm. Okay, it cannot bind other partners, but it can bind the firm. Now, any document that are filed through Ministry of Corporate Affairs portal are public documents, and that can be accessed by anyone after paying a nominal fee. So these documents that you will have to file to the ministry from time to time, they are all deemed to be public documents. You will not have any kind of confidentiality in them anymore. So those are the few advantages and disadvantages. So this is a quick recap of all the important points that there is on Partnership Act unit. Okay, unit 3. I hope you guys got an overall picture of this unit. If you get time, I would suggest after going through this video, kindly do go through that study material which IGNOU has given you. Okay, so that you can get a better understanding when you read the things, right? You will be able to easily grasp the concept now. You won't feel that that unit is demonic anymore. Okay, so I hope this video was useful to you, and until I see you in the next video, bye bye.